Able Solutions presents a presentation by Shlomo D. Katz, Brown Rudnick, LLP.
Hi there, I'm Shlomo Katz from the Government Contracts Practice at Brown Rudnick, LLP, and we'll be talking today about what a proposal professional's role is in a bid protest. Lots of proposal professionals that I've spoken to think that their job is just to get the proposal in, put together the best proposal, the text, the graphics, the cost, or price, and so on, and get it in and then move on to a different proposal. And I'm here today to tell you that that's not really the case, because even though your physical work on the proposal may be done when the proposal goes in, but the proposal that you have written will hopefully become a contract and will be performed over the next 3, 5, 7, maybe even 10 years. And of course, the proposal that you have written, because it becomes part of the contract, will impact what your client or your employer's rights and obligations are for all of those years. And the first thing that's going to happen, even before that, is very possibly somebody will file a bid protest. If you win, somebody will file a bid protest against you. If you lose, you may file a bid protest. And your words in the proposal will be on trial in that bid protest. So writing a proposal is more than just putting together a sales document or a technical document. It's really putting together a document that to a certain extent will determine the outcome of a bid protest. Today we'll talk about why that is, what your role is, and what some bid protest procedures are that it will be helpful for you to understand. So there you see, we'll talk about what is a bid protest, why should a proposal manager care, what is a proposal manager or other proposal professional's role before, during, and after proposal preparation, what are some common protest grounds, which are winners, which are losers, and what you can do to impact their outcome, what are some protest procedures, and how does an offeror or contractor decide whether to protest. Lots of people say, what, sue my customer? I would never do that, but we'll talk about whether that's something you want to do or not. So let's start with what is a bid protest. Bid protests can be heard, federal bid protests, of course, we're talking about, can be heard at two places. One of them is the Government Accountability Office, formerly known conveniently by the same acronym as the General Accounting Office, or GAO. And GAO put out a handy book, which is available on their website, gao.gov, that explains what a bid protest is. And it says, the laws and regulations that govern contracting with the federal government are designed to ensure that federal procurements are conducted fairly. On occasion, bidders or others interested in government procurements may have reason to believe that a contract has been or is about to be awarded improperly or illegally, or that they have been unfairly denied a contract or an opportunity to compete for a contract. Those two sentences that I just read from the booklet, Bid Protests at GAO, a descriptive guide, actually contain a whole lot of information about what a bid protest is. Going back to the second sentence, on occasion, bidders or others interested in government procurements, so you know right away that a bid protest could be filed by a bidder or somebody who's interested in the procurement but may not have bid for certain reasons, may have reason to believe that the contract has been or is about to be awarded, so you know that bid protests can be brought after the contract is awarded or before it's awarded, and that it may be awarded or has been awarded improperly or illegally, meaning that proper procedures weren't followed in some way, or that the bidder has been unfairly denied a contract. That is, maybe there was nothing wrong with the evaluation of the awardee, but there was something wrong with my evaluation, or that the bidder or interested party has been denied an opportunity to compete. Maybe the contract was set aside for small businesses and it shouldn't have been, or it was not set aside and it should have been. So those are what a bid protest is about, and we'll talk about that in more detail now. Why should a proposal manager or proposal professional care? Well, your proposal may be on trial. In a bid protest, one of the issues is typically, was the proposal evaluated fairly and evaluated properly, consistently with the evaluation criteria and any applicable regulations? A lot of that will depend on how well your proposal was written. You might know what you meant, but the evaluator didn't know what you meant, and GAO won't know what you meant, and so your proposal may be on trial. If you understand the risks of a protest, what is a potentially successful protest ground, you can prepare a better proposal which will help you avoid protests against your proposal, as well as do a better job than your competitor, so that if you protest the evaluation of their proposal, you won't have the same problem that you are saying they have. You have the last clear chance to submit a compliant proposal that will be eligible for award. And that's important because one of the mistakes that people sometimes make is thinking, well, my first proposal, maybe I won't talk about this because I know they're going to come back and ask for a best and final, or nowadays it's called a final proposal revision. Well, don't make that assumption. You have the last clear chance to submit a compliant proposal, and it's your job to make sure that you are addressing everything that needs to be addressed in the way that you want it to be addressed. You have the opportunity to give the agency a basis for protest-proof evaluation. The emphasis there is on giving the agency a basis for protest-proof evaluation. Of course, you can't prevent the agency from making mistakes. A lot of protests, successful protests, have nothing to do with what an offeror did correctly or incorrectly. It's more about mistakes that the agency made. So you can't prevent the agency from making mistakes. But if you write the proposal the way it should be written, you are giving the agency something to work with, a basis for protest-proof evaluation. You can support a protest because you know your proposal best, or you can identify the people who do. If you win the contract and there's a protest against the award to you, the primary job of defending the award falls to the agency. But the awardee has the right to intervene, to have its own lawyers also make arguments to defend the award. And you, as the person who put together the proposal, are in the best position to know who knows which piece. If there's a question about Section 13 of the Statement of Work, well, who's the expert on Section 13? Who wrote that? Let me go find him so that he can help the lawyers understand what is here and what is not here and why, and so on. If the protest is sustained, if you won the award and somebody protests and the protest is sustained, meaning that the protest wins, you may have to do it all over again. That may be a good thing, that may not be a good thing. If you have moved on to something else, it certainly could create logistical problems for you. So those are some of the reasons why a proposal manager or other proposal professional should care about bid protests. So what is the proposal professional's role even before the proposal preparation has started? Identify ambiguities in the RFP. That is, something in the RFP is not clear and you need more information in order to bid properly. Now is the time, before you've started preparing the proposal, to identify any ambiguities or any other problems with the RFP. Take advantage of the RFP Q&A process, the question and answer process, when you can submit questions to the contracting officer and get answers, or make a conscious decision not to. What do I mean by that? Well, as you know, any question that you submit to the contracting officer after the RFP is issued will be shared with the entire community of potential bidders. You may have a question about the RFP that having an answer to would help you prepare a better proposal, but it might telegraph your approach to your competitors. And you might make a decision not to ask that question. You'll take a chance on not knowing the answer rather than asking a question that might telegraph something about your technical or pricing approach to your competitors. But it's something you need to pay attention to and think about. Separate what you know from what you speculate or assume. I can't tell you how many times we've been involved in protests where the client just knew something was right, the agency did this or wanted that, or the competitor was doing this or doing that, and it was wrong. And if you make bidding decisions based on what you think you know, based on rather than what you really know, then you're not answering the right questions. A common situation is where the contracting officer and the procurement people are separate from the technical people, the actual users, and sometimes people assume, well, Colonel so-and-so or Mr. Assistant Director so-and-so is going to be the chairman of the SCB, and I know what he likes, so I'm going to write the proposal for him. And often they're wrong. That person is not even on the source evaluation board, let alone being the source selection official, and you thought you were writing to the ultimate decision maker and you weren't. A much better approach is to know what you know and what you don't know and just follow the RFP instructions. You need to understand that the government has immense discretion. What you think is a benefit in your proposal may not be. The government may not think so. You may think that Mr. or Miss so-and-so on the user side really wants this feature and that person's not even there, and therefore what you thought was the greatest benefit the evaluators won't think, and that's not something you could even protest because the government has immense discretion. It knows what it wants and it gets to decide what it wants. You don't get to decide. Know what can and cannot be protested and when. If you have a question about the RFP, if there's some ambiguity in the RFP, sometimes offerors want to say, well, I'll wait, and if I don't win the contract, I'll protest then. You can't do that. There are strict timeliness requirements. Problems with the RFP have to be protested before the proposal due date. You cannot sit on your rights and wait to see if you win or not. The best advice that summarizes all of the above is consult with your attorneys about potential legal issues. Don't wait until after you've lost the procurement and want to file a bid protest to start looking for attorneys. The timelines are very, very tight, and you really want to have good representation that can help you through the entire process, help you understand the legal issues so that you don't lose out on any of your rights. So what are some common protest grounds pre-award? Well, things that are wrong with the solicitation, solicitation improprieties. For example, ambiguities. If it's not clear what the government's asking, now is the time to ask, because if you just make an assumption and you guess wrong, then you'll be answering the wrong question. Overly restrictive or anti-competitive specifications or requirements. Sometimes you look at a statement of work or a specification and you think that it's wired for a particular competitor. It might be, or it might be a mistake. It might be the person who wrote the specification just happened to be familiar with your competitor's solution, but that's not necessarily the only way that the government would accept the work. And if you think it's overly restrictive or anti-competitive, you have the right to protest, but only before the due date for submission of proposals. On the other hand, there may be a specification that contains your proprietary data, which the government has accidentally shared with the entire world, and the only solution to that, to solve that problem, might be to give you a sole source contract. So that is something that you might consider protesting. It doesn't happen very often, but if it does, you have rights. The response time might be too short. The government might be asking for proposals in 7 days, and you need longer. Generally, it should be 30 days unless there's a reason why it's not. I was involved in a protest very recently where somebody filed a protest. The government announced it would take corrective action, amend the solicitation. It did amend the solicitation later that same afternoon and asked for revised proposals by the next morning. Not surprisingly, the original protester protested again, saying, revised proposals by the next morning, that's not fair. But the agency had a reason for it. The work had to start within 10 days. Actually, it was 10 days of award, which by now was only 7 days later, or it could not be done. There was a reason for it. And in the end, the protester decided to drop its protest, and my client was able to perform the work. But that might be an example of when you would protest that the response time is too short. There might be improper clauses included. There might be a Buy American clause that doesn't belong. There might be Service Contract Act in a construction contract or Davis-Bacon Act in a services contract. There might be the wrong data rights clauses. There might be fixed price clauses in a cost reimbursement contract or cost reimbursement clauses in a fixed price contract. Whatever it is, the wrong clauses are there and you have the right to protest that. The solicitation might be improperly set aside or not set aside. It's supposed to be set aside for small businesses if there are two small businesses that could provide proposals at reasonable prices. You might be a small business and you know that there's another small business down the street that could do this work, and it was not set aside, and the agency should have set it aside for small businesses. You could protest that. On the other hand, you might have information that the agency improperly set it aside, that really it could not be done at a fair and reasonable price by small businesses. Before I get to the last bullet, let me give you another example of an actual pre-award protest, actually a pre-proposal submission protest. Really, that would be a better title for this slide. What are common protest grounds pre-proposal submission? I was involved in a case where the Navy had issued a solicitation for maintenance of a very large naval base, everything from keeping the lights on to mowing the grass, keeping the plumbing running, those kinds of things. And they were asking for a fixed price contract for 5 years or so. And the solicitation said we have somewhere between 10,000 and 15,000 plumbing fixtures, but we don't really know how many. And my client said, well, then how can I give the Navy a fixed price for that if they don't know how many plumbing fixtures they had? And we filed a protest in which we said, look, Navy, either you have to change this to a time and materials contract, maybe a fixed price for the first 10,000 plumbing fixtures and then time and materials for every plumbing fixture above 10,000, or you have to put the procurement on hold and go count your plumbing fixtures. And the Navy, after we filed the protest, the Navy took corrective action and did one of those things. It's been many years, and I don't remember which solution they adopted, but they adopted one of those solutions that we had proposed. Now, before you do any of these things, of course, you may want to ask the contracting officer a question. Protests cost money, they take time, and contractors are sometimes worried that they make you look bad. Certainly, if it's something that you could have asked the contracting officer and gotten a simple answer to, and you run and file a protest, it probably does make you look bad. So you first want to ask a question, but if you want to ask the question early enough that if you don't get a satisfactory response, you have time to prepare and file a protest. So the last bullet point here about common protest grounds, pre-award or pre-proposal submissions says bias but ... And what do I mean by that? Contractors, offerors are often see bias. That person doesn't like me. That person's a former employee of my competitor, or that person is someone I fired 20 years ago, or that person just thinks I looked at him the wrong way, and he doesn't like me, and he's going to be on the source selection board, and that's inherently unfair to me. Sometimes that's true, but the overwhelming majority of protests alleging personal bias will lose. Government officials are presumed to act in good faith unless you have very specific information showing that a government official is biased. Don't even raise the question. That will make you look bad. Stick to the technical, legal issues and don't get personal with your litigation. Now, you may have a justification to. Maybe you really do have facts, and in that case, then there will be occasions to bring a bias protest. There was a case about 20 years ago where the same company that was evaluating the proposals, helping the government evaluate the proposals, was a subcontractor to one of the offerors. Well, that's a clear bias situation. But that will be rare. The government's not that incompetent. And that will be very rare, and you don't want to go around accusing people of bias unless it's absolutely necessary. During the proposal preparation, until now we've been talking about when you first get the RFP and you look at it and you identify problems with it, then you start preparing your proposal. What is the proposal manager's or proposal professional's role during proposal preparation that will help with a bid protest later, that will help you win and keep the contract? Again, account for ambiguities in RFP. Maybe you decided not to ask a question about an ambiguity, or maybe you asked a question and did not get a sufficient answer. So you want to account for any ambiguities. And you do that by saying, Our proposal assumes the following. If it's not clear if the government is providing certain government-furnished equipment or certain software, or it's not clear what the government's schedule for vacating the building is so you can tear it down, well, you need to say in your proposal, our assumption, our proposal is based on the government evacuating the building by August 1st, 2015. Our proposal is based on the government providing the following software. Any ambiguities, account for them. That will make it easier for the government to evaluate. And incidentally, if there's a dispute 3 years from now about whether you performed what you promised to perform, you can point to that and say, well, look, I said we're only going to do this if you give us this software, and you never gave us this software. Write a compliant proposal. Stick to the instructions that are given, not only the obvious things like page numbers, but if they tell you that something should be discussed in Section 5, then don't discuss it in Section 4. Or if you must discuss it in Section 4 and you don't have room to discuss it again in Section 5, at least put a very, very clear cross-reference. I discussed this on page so-and-so. You cannot expect the evaluators to go looking for information. In fact, sometimes different people will evaluate different sections, and if the evaluator who's evaluating Section 5 is expecting to see you talk about schedule and you didn't talk about schedule in Section 5, you put in Section 4, the evaluator will say there was no schedule. So write a compliant proposal, put everything that should be there, put it where it should be, and answer the questions that the RFP is asking. Include in the proposal any information you want the government to consider. This is particularly a significant issue for incumbents, but also for others. Sometimes offerors assume that the government knows all about me. I've been working with that agency for 10 years. They know me. I don't have to waste valuable proposal pages telling them my corporate experience. They know my corporate experience because my corporate experience is with them. That's not the way you write a proposal. If somebody would protest, how could you award a contract to Katz? He didn't talk about corporate experience. It's not an answer that they already know my corporate experience. I was supposed to talk about it. Again, separate what you know from what you speculate and assume. Don't write to what you think the requirements are. Don't write to what you think the evaluator wants. Write to what the RFP is asking for. And by the way, if you then don't win the contract, because the evaluator says, they tell you in the debriefing, the SCB was looking for you to talk about recording movies, and you didn't talk about recording movies, you'll file a protest. You'll say, where in the RFP did it say anything about recording movies? It didn't. So, you may have wanted it, but you didn't put it in the RFP. That's not a valid basis for marking down my proposal. And you will win that protest, unless, of course, there's some hint to recording movies in the RFP that you missed. Again, understand the government has immense discretion. This will be a recurring theme when you talk about protests. The government has immense discretion. So what you think is something really special or a great benefit might not be a really great benefit to the government. And again, know what can and cannot be protested and when. Know what is a pre-proposal protest versus a post-proposal protest. Know what's a pre-award protest versus a post-award protest, and when is the proper time to file each one. Once the award has been made, you can still make a timely debriefing request. Debriefings are not only for losers. Debriefings are for winners also. I am involved in a case now. It's a contract dispute. The contract was awarded 5 years ago. It's being performed now, and there's an issue that arose, and one of the pieces of evidence is the debriefing that my client got. Now, they were the winner, but they got a debriefing, and in the debriefing, the government said such and such. I'm not going to talk about specifics, but the government said something in the debriefing which is now playing a role in a contract dispute 5 years later. So the winner can get a debriefing too, and you could get useful information, not only useful information that will help you prepare an even better proposal next time, because even winners can improve, but useful information that will help with potentially contract performance or contract disputes later. If you're the loser, you certainly want to make a timely debriefing request. If it is a procurement conducted under FAR Part 15, which involves negotiated proposals, then you have to submit your debriefing request within 3 days of getting the notice of award, and then you wait for debriefing, and you file a protest after the debriefing. If it is a procurement conducted under some other part of the FAR, FAR Part 12, commercial items, FAR Part 36, for architect and engineer services, different timelines will apply. Another reason to have a lawyer to help you understand the timelines that will apply to your specific procurement. Not all procurements are the same, so you don't want to assume, well, it's 3 days to request a debriefing and then 5 or 10 days after debriefing to file a protest. Have a strategy and prepared questions in advance of a debriefing, but when you do that, your questions should focus primarily on things that the government is allowed to tell you. The FAR in 15506 tells you what the government should tell you in a debriefing. Sometimes agencies will tell you things they're not required to tell you or not even supposed to tell you. Sometimes they will not tell you things they're supposed to, but you can help the process by preparing questions in advance, and the agency may want you to submit them in advance. That way the agency can have answers prepared. What I do when I prepare questions for a debriefing is I follow closely the format in FAR Part 15, and I ask about my strengths and weaknesses. I ask about my price and the winner's price. And then there's a section for other questions, and there I include the other questions. If there are questions that might be sensitive and might make the agency angry, I don't necessarily submit those in writing beforehand. I might save them to ask at the debriefing if I feel there's a reason to. Sometimes there might be a reason to make your client angry, your potential client angry, but you don't want to do that if you don't have to. So you'll hold those questions back in reserve. Generally, clients want to ask questions about bias, and I discourage that because it's usually not helpful. Those are some of the considerations that go into preparing questions. Then, after the debriefing, your responsibility is to support your organization in making an informed decision whether to protest. What did the government say in the debriefing about my proposal, and were they right? If the government says you forgot to talk about X, Y, and Z, are they right? We didn't talk about it. Or maybe it's on page 17 in a little box and the government just missed it. And as the proposal professional, you're in the best position to answer those questions for your corporate management and your attorneys, to tell them the government's right, I blew it, or the government's wrong. That information that they say wasn't there is there. And you want to feed useful information to your attorney. Just one caveat, don't be insulted if the blockbuster information that you feed to your attorney doesn't think is important, because your attorney knows what are winning protest grounds and what are losing protest grounds, and what you think is very important information isn't necessarily. And on the other hand, something you think is not important might be very important. So you want to feed as much information as you can to your attorney, but give your attorney time to evaluate it, to think about it, and to decide how it fits together with the law and the facts, and maybe it's useful, maybe it's not. So what are some common protest grounds post-award? What you're protesting is the evaluation and the failure to make an award to you. That means you're protesting the agency's failure to follow the evaluation criteria or other RFP requirements. If the agency said technical will be most important, and it looks like the agency made price the only consideration, sometimes a best value procurement that should have technical and price traded off, the government turns it into a low price, technically acceptable evaluation. Well, that's wrong, and that's protestable. And so you would protest the failure to make a proper trade-off best value analysis if that was the evaluation scheme in the RFP. On the other hand, if it was low price, technically acceptable, I've seen sometimes people who want to protest the fact that they didn't get strengths for they're proposing, ABC. Well, guess what? It's not relevant. If it's low price, technically acceptable, you shouldn't have put in the strengths, because all that's relevant is whether you're acceptable or not, and then you want to go for low price. You might protest the improper assignment of weaknesses or the failure to assign strengths to your proposal. In the debriefing, you'll find out what weaknesses were assigned and what strengths were assigned, and you'll say, well, how come you didn't assign a strength to my ABC feature? Well, remember, the agency has immense discretion, and they might not have thought that your ABC feature is a strength. But then you find out that the agency or your competitor issues a press release saying, we chose John Doe Corporation because they offered ABC feature, which was a great strength. Wait a second, I offered ABC feature. You didn't give me a strength for that. So that would be a basis to protest. And that's really the next bullet, improper assignment of strengths or failure to assign weaknesses to the awardee's proposal. Maybe you were assigned a weakness because you had a cost overrun on another contract, and you know that your competitor had a cost overrun in a very similar situation, and you have reason to believe they were not assigned a weakness. Of course, you don't know at this point, so there is some speculation, but you have to have basic facts enough to get your foot in the door so the GAO doesn't throw you out. You might protest the evaluation of cost-price realism. For example, we had a protest years ago where the agency awarded to one company that was significantly below the government estimate. This was a multi-billion-dollar contract, and they were maybe $1 billion below the government estimate. Somebody else came in and protested and said that during discussions, you encouraged us to raise our price. So we were slightly below the government estimate, and you encouraged us to raise it to where we ended up above the government estimate, and then you went and awarded to someone who was $1 billion below the government estimate. You could not possibly have done a reasonable cost realism analysis if you came to such different results for us and them, and you misled us in discussions. And that was a winning protest because the government had misled them by encouraging them to raise their price when the government actually was looking for a very low price. Definitive responsibility criteria is another way of saying compliance. If the government says, give me a project manager who has a PhD and 30 years experience, then you better give them a project manager who has a PhD and 30 years experience. If your competitor gave them a project manager who has a master's degree and 25 years experience, they failed to meet a definitive responsibility criterion. They were not compliant, and they should not have won the contract. And then the last one is bias. We talked about that already. Be very, very hesitant to raise bias in a protest. Additional common protest grounds, exclusion from the competitive range. That is something that has its own timeliness requirements. If you are excluded from competitive range, you need to protest within 10 days of when you are excluded from competitive range. Don't wait until someone else wins the contract. And just a little tip, I hope there aren't too many contracting officers watching this, but my experience is that if you protest exclusion for competitive range, you may have a good chance of getting back in because it's often not worth the government's effort to fight you on that. If you're not going to be the winner, then you're not going to be the winner, but why should they fight you on a protest on that? It's not a guarantee that you'll get back in, but it seems to be quite common. Another thing you can protest is cancellation of the RFP. If the government canceled it and you've invested a lot of money in it, you don't want it canceled, you could protest that. Rejection of a late or non-compliant proposal, and you think you weren't late or you have a valid excuse. There aren't a lot of valid excuses for a late proposal, but there are some. You could protest that. Organizational conflicts of interest. If the winner has an OCI, for example, the winner wrote the specification for this procurement. They should not be allowed to bid on it generally, and that's something you could protest. Or if you were excluded for an alleged OCI and you don't think that's valid, then you could protest that. And again, these are all things that proposal professionals may have unique insight into because they've been working with this RFP and they've been working with the requirement for a long time, and they know it better, certainly better than the lawyers, and they know it better than the senior management. And so these are all things that they'll have input into. Until now, we've talked mostly about things you could protest, but really you don't want to protest. Protests cost money, they take time, and you want to minimize protest risks. Well, what can you do as a proposal professional to minimize the protest risks? Your proposal should make clear what you are promising and what you are not promising. As I mentioned before, if you're only promising to tear down the building if it's evacuated by August 1st, then say so. If you're only promising to finish in the next year if the government gives you certain software, say so. Make clear what you're promising and what you're not. Demonstrate your cost-price realism by relating your actions and deliverables to resources. A proposal that says, we will tear down the building for $1 million in 30 days is not as realistic as a proposal that says, we will tear down the building for $1 million in 30 days using the following equipment, the following personnel. The first week we're going to do this, the second week we're going to do that. It enables the agency to evaluate your technical proposal and your cost or price realism by relating actions and deliverables to resources. Now, you're not supposed to put cost information in the technical proposal, and you put only limited technical information in the cost proposal, but so you're not going to say in the technical proposal that we're going to use, 3 bulldozers and they cost this much. That would go in the basis of estimate in your cost volume, but you certainly can say in your technical proposal, we're going to use 3 bulldozers and 10 people and do this on the first day and so on. Your proposal should not be based on information you have no right to have. That is a good way to draw not only a bid protest, but civil litigation. We had a case years ago where our client was actually a subcontractor to the winner, and the loser filed both a bid protest and a federal court trade secrets lawsuit saying that one of their key people had gone to work for our client, the subcontractor to the winner, and the trunk of her car was full of documents from her former employer. It was true. And the new employer paid millions of dollars in damages, and that's not a situation you want to be in. One of the things I do in my professional work is draft employment agreements, and most companies put in their employment agreements, you will not steal our trade secrets. And that's a good thing to do. But I always add to an employment agreement, you will not bring me your former employer's trade secrets. I don't want them. They're really not useful. They might seem useful in the short term, but they're not. And don't promise anything you can't or won't deliver. Just some cute statements found on the internet about promises. Promises are like crying babies in a theater. They should be carried out at once. And Abraham Lincoln said that we should not promise what we ought not, lest we be called upon to perform what we cannot. If you make a promise, then the government's going to expect you to do it. And if you can't, you might be looking at default termination, which is not a good thing for a government contractor or any company. This really just summarizes some of the things we've said before. You could say, we will do such and such, or you could say, we will do such and such if. And that may be dependent on government-furnished equipment or government-furnished software, may be dependent on the government meeting certain schedules. If you're going to make promises, state your assumptions, state the conditions on which your promises are dependent. If you're promising to include certain components in the system, so some people might say the following components are included in the price. That way you have made very clear what's included. It's even more clear if you say what's not included. The following components are included and the batteries are not included. They cost extra. Or this price is conditional on the government providing the following government-furnished equipment. Do not use the passive voice. The following components will be provided by others. It doesn't say by whom. It doesn't say when. Maybe it's you. Others maybe means not this person, but that person from your organization. So you want to say this proposal is conditional on the government providing such and such by such and such date with the following characteristics. Make it very clear what you're promising and what you're not promising. Don't say our proposal includes all the necessary equipment. Say our proposal includes 2 of the following pieces of equipment and 1 of the following pieces of equipment for 3 calendar days. That will help the government evaluate your realism, that will help the government understand your technical approach, that will, in the event of a dispute years down the road, well, why didn't you provide 6 Caterpillar 953Ds? You'll say, look in my proposal. I told you I'm providing 2 Caterpillar 953Ds. So what are some typically winning protest grounds? One of the best ones is that the agency's evaluation did not follow the evaluation criteria. The evaluation criteria said past performance was twice as important as technical and 5 times as important as price, and then the agency ignored past performance. Or the opposite, the agency's evaluation relied on factors that were not identified in the solicitation. It didn't say anywhere in the solicitation that they're going to evaluate the color of the computers I'm providing, and they did evaluate them. Now, you need to be careful there, because the rule is that not that the evaluation factors and significant sub-factors need to be stated, but anything that's reasonably related to those factors or major sub-factors is fair game. So, of course, the color of the server is probably not related to a factor or a sub-factor, but the qualifications of key personnel, even if they're not specifically called out, it's certainly reasonable. If it's a construction contractor, it's reasonable for the agency to comment on the fact that your program manager is, a professional ballerina with no construction experience, even though it didn't say anywhere in the RFP that they were going to evaluate that. Another protest ground is that the agency's evaluation of offeror's experience relied on distinctions that are not supported by the record. Maybe they said that the other company had relevant experience and you didn't, when in fact your relevant experience is identical. Or maybe they gave the other offeror credit for experience that was not mentioned in the proposal, but they did not give you credit for experience that was not mentioned in your proposal. Or maybe they failed to evaluate an important section of your proposal altogether. That's rare. Evaluators are usually pretty competent people, and they don't just skip 10 pages of your proposal for no reason. Sometimes it just wasn't written as clearly as you thought it was written, and it might not be a winning protest ground, but keep it in mind, it is a potential protest ground. More examples of winning protests: the source selection decision considered an undisclosed evaluation criteria, and that's similar to the evaluation considering undisclosed evaluation criteria that we talked about before. The agency did not reasonably support a claim that only one firm is capable of meeting the agency's needs. That would be if the agency awarded a sole source contract and you could have done the work also. The agency's proposed sole source award was longer than necessary to meet the urgent need. For example, we had a successful protest many years ago against, it was an Air Force sole source contract to perform certain services for 5 years. The agency said, we have an urgent need for these services. And we protested, and GAO said, Air Force, maybe you have an urgent need for these services for the next year, but you don't have an urgent need for 5 years. You could award a sole source contract for a year and conduct a procurement during that year. And we won. So that's an example of a winning protest ground. The agency might have issued a notice of intent to issue a sole source contract, which is theoretically designed as a marketing tool to see if there are potential competitors out there, but it was written in a way that discouraged competition, or the requirements were so specific to the one company that it made it look like no one else could do the work when someone else really could do the work. We had a protest in which GAO found that the agency's notice of intent was actually written to discourage competition. GAO usually doesn't say things like that. GAO usually is very factual, very bland in its decisions. You won't find any slang in their decisions, for example. And in this particular decision, GAO said, the agency looks like it did not want competition. It was avoiding competition. So that is something to look out for as well. On the other hand, common reasons protests are denied because the agency's evaluation was reasonable and in accordance with the solicitation's evaluation criteria, you just happen to disagree with it. And GAO says it's not our job as GAO to reevaluate proposals and apply our judgment. Our question will simply be, was the agency's judgment reasonable? Not did the agency make the best possible decision, Not would we have made the same decision the agency made, but was the agency's evaluation reasonable? If the protester merely disagrees with the agency's technical evaluation, the protest will be denied. A price technical trade-off was reasonable where the source selection official reasonably identified technical distinctions between competing proposals and explained why one was worth more money than the other, even though the price was higher. Another common reason why protests are denied is that although the proposal offered to comply with solicitation requirements, it did not explain how. Don't just parrot back what the solicitation says. So let's talk a little bit about bid protest procedures. Protests can be filed, and this is true both before proposals are submitted, pre-award, post-award. You can submit an agency protest, which has the evaluation of kind of allowing the agency to wash its own dirty laundry in private. It doesn't bring GAO or the courts into it. You could file a GAO protest. You could file a protest at the U.S. Court of Federal Claims. And if you have a size protest, that would go to the Small Business Administration. And of course, state and local governments also have their own procurement systems and protest processes. Who can protest? An interested party. An interested party means an actual or prospective offeror whose direct economic interest would be affected by the award of a contract or the failure to award a contract. So a union, a labor union, would not be an interested party. They weren't planning on bidding on the contract. Their interest is that their workers need work, their members need work. Well, that does not make them an interested party to file a protest. But a company that would bid, if not for this restrictive requirement, or a company that did bid and didn't get the contract, would be an interested party to protest. There are different timeliness requirements. A protest against solicitation improprieties needs to be filed before the next due date for submission of responses. And by next due date, I mean that you might be protesting something that's in an amendment to the solicitation, which changes the due date. So whatever the next due date is when you have to file your protest. If you're protesting the evaluation of proposals and failure to make award, and it was a FAR Part 15 procurement, then you have 10 days after the award if it was not a FAR Part 15 procurement, or 10 days after a required debriefing if it was a FAR Part 15 procurement. But if you want to get a stay, then you have to file within 5 days after the debriefing. And there are special timeliness rules for protests alleging ethics violations. Once a protest is filed, GAO is going to issue something called a protective order. A protective order says that the agency has to, in order to resolve this protest, the agency has to submit lots of information to GAO about your proposal and your competitor's proposal. And of course, it would not be fair for your competitor to see your proposal or for you to see your competitor's proposal. So the agency issues a protective order, which the lawyers for both sides have to apply for admission to, is a technical term. And when we do that, we are taking an oath that we're not going to tell you things we're not allowed to tell you, which basically means we cannot tell you anything unless all parties have agreed that we can tell you. And then we'll get the agency report, and each side will file their briefs on the agency report. They're technically called comments on the agency report. It's very frustrating for clients that they're waiting to hear what's going on, and all we can tell them is, the agency filed an agency report. It has some strong points, but we have arguments, and we can't tell you what they are. And it might be days or weeks until we can tell our clients anything. And it is frustrating. It means that sometimes we ask our clients questions, and the client, getting back to the point I made before about separating what you know from what you speculate, if I'm working on a protest for you and I ask you a question, don't try to guess why I'm asking. Just answer my question. Your guess might be on the mark, but I can't tell you. Your guess might be way off the mark, in which case, what was the point of guessing? And if you try to interpret my question, you're not going to give me the meaningful answer that I'm looking for. So protective orders make meaningful attorney-client communication difficult, but not impossible. Answer your attorney's questions. Of course, if there's any information that you think is relevant, bring it to your attorney's attention, but your attorney might not be able to tell you if it's relevant or not, and that can be very frustrating. Sometimes you're going to get redacted documents that will look like one of these pictures here. It might be the entire page is redacted except for the word "the" on one line, or it might be more selective and you'll be able to get a basic idea of what the arguments are, but not the facts that support those arguments. Those are called redactions. And again, it's part of the frustration that clients sometimes feel. The agency will submit an agency report that contains the relevant facts, a memorandum of law, and copies of relevant documents for GAO and the parties to review. In rare cases, the protester will be asked to produce documents. In all of my years of practicing, I don't recall that ever happening. Usually it's just the agency's evaluation record, which is on trial, and the agency's evaluation record should include all of the proposals and the evaluation documents. So the agency has everything. It would be pretty unusual, extremely unusual, for the protester to be asked to produce documents. So what is the proposal professional's role during a protest? Answer your attorney's questions, provide concrete information, and proposal citations. I could read your proposal, but you know it best, and I'm trying to save time by asking you, where did you talk about the project manager's qualifications? So you'll tell me it's on page 17. Now what happens sometimes is that you think you talked about it on page 17, but I see the arguments that the protester and the agency are making, or maybe we are the protester. I see the arguments that the awardee and the agency are making, and you really didn't talk about it as well as you think you did. And I might come back and ask you, is there anywhere else you talked about it? Just give concrete information with citations to proposal pages and figures and tables where the information is. Don't make assumptions about why I'm asking the question, because that's not going to get me useful information. Again, always remember the agency has immense discretion, so it's not helpful for you to tell me, well, I think the agency should have liked this. You could tell me concrete reasons. The agency should have liked this because the agency has had problem X for 10 years, and this is going to solve problem X in the cheapest, most efficient way. And they should have treated that as a benefit or a strength, and they didn't. That's concrete. It tells me why the agency should have liked it and what your evidence is. That doesn't mean you're going to win, but it's better, a lot better than your opinion, which is really, unfortunately, irrelevant. Should we protest? Every year, GAO issues statistics going back 5 years. So recently they issued the statistics for fiscal year 14 and 2014, and you can compare them to the 4 years before that. And you can see that the sustained rate, the number of protests outright sustained, where there was a decision in favor of the protester, was quite low, only 13%. A more significant statistic, I believe, is the effectiveness rate, which was 43%, and you can see that that's pretty constant over the last 5 years. The effectiveness rate measures when the protester got some relief. It might have been a decision, it might have been an agency do-over, which is called a corrective action. It might have been a mediation between GAO and the agency that resulted in some relief for the protester. That's more significant than the sustain rate, which is whether GAO wrote a decision, because the effectiveness rate means you won something. So that gives you the hard facts on whether you should protest. There are lots of arguments that people make about whether to protest or not, but they're our customer. How can we sue our customer? The answer is that the government knows it's part of doing business. And as long as you stay professional, don't start throwing around bias allegations and calling people names. And believe it or not, I've had clients who have done that. That's not going to help you with your customer. But a professionally written protest that addresses the legal issues is part of doing business. The government understands that, and it's very rare that it will be held against you. You want to consider who's really going to benefit from a protest. If I protest on this, am I going to get the award, or is it going to go back for corrective action and a different company is going to get the award? I'm not really in the best chance to win this, so why should I bother? Who will benefit from a stay? If you're the incumbent and you have a mediocre protest, now you can't file a frivolous protest, but you have a protest that might win and might not, but if you get a stay, you can perform for another 100 days. So that's a consideration. How strong is my case? How much will it cost? Protests that I've been involved in have ranged in price from $50,000 to millions of dollars. What will we gain and lose? If you win the protest, you might get back some of your attorney's fees. If you're a small business, you might get back more of your attorney's fees, but there's a cost. Are there alternatives? Can I get a subcontract from the winner and get some of the work? Is there a potential settlement? Again, I've seen protests that have been settled by the protesters getting subcontracts. So that, in a nutshell, is what you as a proposal professional need to know about bid protests. Hopefully with that information, you can not only write better proposals, but support your organization better in the event that there is a bid protest. Thank you for listening.
This has been an Able Solutions production.